can I sue USCIS if my naturalization case is delayed? And the answer is yes. There's a little known rule that many don't know about, which states that 120 days after your naturalization interview, the USCIS officer reviewing your case must make a decision. So the bottom line is, under 8 USC 1447B, that's the statute, you can sue USCIS in federal court if USCIS has not made a decision within 120 days of your naturalization interview. So why is this important to you? It's important because there's many naturalization cases that are stuck in delay, and a lot of times people reaching out to us for consultations are asking, what can we do? We've reached out to the congressman's office, they've filed a request and nothing's happening. I've used the USCIS online case tool, nothing's happening. What can I do? And this is why I'm shooting this video, is to explain that you have other tools, namely this 1447B lawsuit, that you can use to your advantage. And let me illustrate this through an example of how well these lawsuits work, through an example in a case we recently had. So our client was living in Brooklyn, New York. She had moved to Manhattan, New York, just across the river, while her case was pending. She attended her naturalization interview, actually went with her. She passed both her English as well as the civics test. And the officer said, oh, I can't make a decision because you had moved from Brooklyn to Manhattan, again, just across the river in the same city. So now the case is with the New York, Manhattan office, so you have to wait. So we waited for several months. Nothing was happening. We reached out to the congressional office. They tried to expedite the case, but USCIS responded to them that, oh, there's nothing we can do. You just have to wait. Well, because I had worked for the Department of Justice before and represented the government in these cases, I knew that this 1447B lawsuit was something that we could use. So what we did was we waited 120 days, and then we sued in the district court, in this case the Southern District in New York. Within a few days of filing our lawsuit, the Department of Justice attorney contacted our office. We had a discussion, brief discussion, frankly, over the phone. The government understood immediately that they have to make a decision under 1447B. We agreed to dismiss the case, and a few days after that, USCIS had scheduled my client for for an oath ceremony. So the bottom line is, in using the congressional request as well as the online USCIS tool, we got pushback from USCIS telling us that, oh, there's nothing you can do, you have to wait. But the moment we sued, within a few days, the oath ceremony was scheduled. So I'm using this example just to highlight how effective this can be. And I tell everyone the idea isn't to sue all the time, and that you don't have to think that this is absolutely necessary every time. But it's a tool that you must know about and you should use. If you've been waiting more than 120 days, it's a black letter rule of law, 1447B, that specifically says that's all the time USCIS gets. So if you need to become a U.S. citizen for whatever reason, right? You want to work for the federal government, you want to vote, you want to petition for a family member's green card, do not wait and do not feel that you don't have options. You do have this option, and it's incredibly effective. And I can tell you, as having been on the other side of these cases, having worked for the government, there's not many arguments the government can make unless there's something really, really wrong with your case. I mean, 120 days is more than sufficient to adjudicate one of these cases. So again, if your naturalization interview has occurred and more than 120 days have passed, you can petition in federal district court in order to receive a decision on your case. I hope you found this video helpful.